We have a motion on the table and a second to approve the minutes from the last meeting. All in favor say aye.
Aye.
Aye. All right, the meeting, or the approval of the minutes have been approved. Next item on the agenda is dispensary renewals, and we're gonna try to mix it up and do it a little bit different than we've done it before. Are you guys okay with going ahead and just batching these by zones? Okay. Well, on zone 1 dispensaries, I'll make a motion to go ahead and batch A through E on zone 1.
Okay, so maybe these are working, maybe they're not. But I'll be loud. In the Zone 1 dispensaries group, we have A through E. That is permits number 309, 121, 278, 189, and 113. These, along with all the others we'll talk about today, have provided certificates of good standing, tax clearance, new organization charts, and updates to compassionate care plans. They've all been vetted by ABC with no issues.
Okay, I'll make a motion to approve the renewals for zone 1.
Second.
We have a motion on the table and a second to approve renewals for zone 1. All in favor say aye.
Aye.
Aye. Zone 1 has been approved. Zone 2.
Okay, we will move on to Zone 2. That is permit number 40, number 192, number 46, number 155, and number 63. Again, those were vetted by ABC and subject to no issues with the Attorney General's office. We didn't see anything that we were worried about.
I'll make a motion that we approve, zone 2. Second.
We have a motion on the table and a second to approve the renewals for zone 2. All in favor say aye.
Aye.
Aye. Next item is zone 3.
Moving on to Zone 3, we have permit numbers 35, 206, 290, 29, 198. Tax clearance, good standing, organization charts, everything looked fine by ABC. We saw no issues in our vetting, subject to any issues AG's office may or may not have.
And yeah, based on our limited review renewals, we didn't have any issues on what we looked at.
I'll go ahead and make the motion that we approve zone 3.
I'll second the motion.
We have a motion and a second to approve zone 3 for renewals. All in favor say aye.
Aye.
Aye. Zone 3 has been approved. Now, zone 4, I'm going to recuse from permit 117. I'm going to turn it over to Kevin.
Okay, we're gonna look for zone 4 with 117 recusal, then we'll turn that over to you.
On that permit specifically, ABC, and my understanding is the AG's office found no issues with that.
So I'll entertain a motion to approve 117.
I'll make a motion to approve 117.
Second. Have a motion and a second. All in favor say aye. Aye. Motion carries.
All right, the next thing on the agenda is to approve the rest of zone 4.
Correct. So that leaves us with permit number 158, permit number 33, 162, and 258. ABC saw no issues.
AG's office.
And based on our limited review of renewals, we had no issues either.
I'll make a motion to approve the rest of zone 4.
Second.
We have a motion on the table and a second to approve the rest of zone 4. All in favor say aye.
Aye.
Aye. Next item on the agenda is zone 5.
In Zone 5, we're looking at permits number 267, 145, 126, 249, and 277. We saw no issues in our vetting of those.
And we had no issues with the documents we received and what we reviewed. And my understanding was the tax documents that ABC received all for.
Yes, we received tax clearance on everybody that we are recommending approval for today.
I'll make a motion to approve.
Second.
We have a motion on the table and a second to approve, zone 5. All in favor, say aye.
Aye.
Aye. Next item on the agenda is zone 6.
Zone 6, we have permit number 31, 281, and 154. ABC saw no issues.
And again, no issues from our side.
I'll make a motion to approve zone 6.
Second.
We have a motion on the table and a second to approve zone 6. All in favor, say aye.
Aye.
Aye. Next item is zone 7.
Zone 7, we have permit number 32, 19, 222, 272, and 106. ABC saw no issues with those.
Based on my documents and scope of review, no issues.
I'll make a motion to approve renewals for zone 7.
I'll second the motion.
We have a motion on the table and a second to approve zone 7. All in favor, say aye.
Aye.
Aye. Zone 7's been approved. Zone 8.
In Zone 8, we have permit number 245, 97, 161, and 156. ABC saw no issues with those upon our review.
Within our scope of review, no issues.
I'll make a motion to approve zone 8.
Second.
We have a motion on the table and a second to approve renewals for zone 8. All in favor, say aye.
Aye.
Aye. All right, next item on the agenda are cultivators.
Yes, this is permit number 11, permit 26, 65, 70, 83, 88, 120, and 123. We saw no issues in our review of those.
And there were no issues within our scope of review as well.
Tracy, did you want to add that 7-day thing into this, or you want to add it at the end?
As soon as y'all vote, I will
Okay.
speak up on that.
I'll make the motion that we approve cultivation.
Second.
We have a motion on the table and a second to approve the renewals of all cultivators. All in favor, say aye. Aye.
And the only comment is just a friendly reminder, I know most of y'all know this, there will be 7 days from the written notice to pay for cultivators only. That is by either our rule or statute, I can't remember which one. But we have decided we're not gonna try to cram everything through tomorrow, just in case we have any kind of tech issues. So be looking for your written notice on Monday, which would mean the following Monday is the day to pay for cultivators. And that's all I've got on that one.
Okay,
That's a holiday.
Oh, is it?
The following Monday is a holiday.
Well, I'm glad I said that, and you said got it. We'll send them out on Tuesday, and then we'll have the due date the following Tuesday. Executive decision there.
sounds good. Next item on the agenda are processors. I would like to pull permit 337 and see, go ahead and explain. 337.
Sure, I will. We can batch the processors except for permit number 337, Happy Turtle Processing. They are still not open, and there are some technical issues within our system that kind of created an extra permit for them and undid it. So we're waiting on a few things on them, but we'll put it back on for the June agenda.
Okay,
But outside of that, we can go ahead and batch the other processors.
okay.
So that will leave us with permit number 327, 332, 329, 330, 335, 336, and 341. And we saw no issues with this.
Council.
And no issues with the documents we received in our scope of review for them.
I'll make a motion to approve all the processors except for permit 337.
Second.
We have a motion on the table and a second to approve all processors except for permit 337. All in favor, say aye.
Aye.
Aye. All right, we are through with renewals.
Yes, and I will say good job to everybody. I know all the attorneys were working very hard getting their paperwork in. Thank you for being nice and polite to our staff and helpful in everything. You guys did great. We didn't have any huge hiccups this year, so that was good.
All right, next item on the agenda is transfer of ownership, permit 154.
That's correct. We received a transfer of ownership request on permit 154 Custom Cannabis. The owner that they're requesting to add is someone who's been previously vetted and approved by ABC, so we saw no issues with this.
And based on the documents we received and reviewed, we didn't have any issue that appears sufficient.
Commissioners, any questions, comments? Seeing none, I'll entertain a motion.
I'll make a motion to approve.
We have a motion on the table and a second to approve the transfer of ownership for permit 154. All in favor, say aye.
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 Next up, under transfer of ownership, we have permit number 11, Revolution. This again was an owner who's been previously vetted, or actually I think has appeared on the agenda before. So in the process of appearing on the agenda has been vetted by ABC and we saw no issues.
Based on the documents we received and reviewed, we didn't have issues.
Commissioners, any questions, comments? Seeing none, I'll entertain a motion.
I'd like the motion to approve, permit 11, transfer of ownership.
Second.
We have a motion on the table and a second to approve the transfer of ownership for permit 11. All in favor, say aye.
Aye.
Aye. All right, next item on the agenda are administrative matters.
Yes, so I know we've talked a little bit about rules with legislative session that kind of drew our attention, not to mention ALC wasn't meeting. So now it's time to kind of get back on focus with rules, but there are two different things. One are the licensing rules, which were started in 2022 and were paused for litigation. Those rules were approved by the previous governor's office administration, but now that BLR has switched everything into a code of regulations, we have to reformat the way they look to submit them to BLR to get them to ALC. So in line with doing that, we are also going to need to run them back by this governor's office for approval. So that's where we're at on licensing rules. On management rules, we had done one public comment period, and we're waiting to kind of do a second one based on the comments we did receive. We believe that we're hoping that we can plan to run both of those at the same time. So that way public comment, the first public comment on the licensing and the second public comment on the management rules could just be at the same time. And then you guys could vote to approve those at the same time. There will be a little bit of orchestrating when you approve it, when it runs in the newspaper, when the ALC meets. So once we have dates certain for you, we will get you that information.
So when you say licensing rules, we talk about the last two permits and one in zone 6 and one in zone 8.
It is, yes, it is the package of rules that was presented that was paused by litigation, which would allow for y'all to issue out those remaining licenses.
What's the time frame on that, you think?
Probably realistically not till the end of summer because you're going to do at least a month public comment period. Plus we have to plan in advance to get it in the newspaper for that. You'll have to approve it before that. And then it has to go to ALC, then ALC meets. So reasonably the end of the summer.
Okay.
Also, the next big hurdle, we got through renewals on permits. The next big thing is rec card renewals. Just kind of friendly reminder that's coming up next. If you guys have any questions, you can contact Tanette. She is our new rate card specialist in the marijuana division. If you can't catch her, contact one of the attorneys and we'll find somebody to help you out on that. Also, I think we just have to set the next couple meeting dates and then that's all I've got.
Okay. The June meeting is when?
June 5th. And I already had that on my calendar, so I can't remember if we did tentative or not, but we've at least talked about that date before.
Okay, so the next meeting is going to be set for June 5th at 2:00. And since July is right before July 4th, so let's set the next meeting for July 10th at 2:00. So June 5th, 2:00, and June 10th, 2:00. Okay, I've had a couple requests to have a couple people speak on the transfer of location that we did. Was the last meeting or meeting 4 on one in Northwest Arkansas, and then I was going to allow them to speak. Who all's here? We have 2.
Either me, but it's so like for me, it just
Okay.
what your call is as to whether to allow him to speak or not, or just me, so,
Well, how about both of you come up?
okay? Thank you.
Will you introduce yourself for the record?
I'm Michael Langley.
Michael, tell us.
I'm loud, everybody knows that, so I'm not worried about that. I'm Michael Langley, I represent the Source Dispensary. Mike is one of their main officers and operators, and I appreciate y'all giving us the opportunity to be here and speak today to make sure everybody understands what the issue is. The issue is we're here to ask for a motion to rescind the prior approval. Not to overturn it, not to do anything other than to get us back to square one in all of this. It's kind of an odd situation, I understand it. The MMC does not have any rules about how to conduct a meeting beyond what's in the Constitution, which says you just have to have a majority of the quorum. So essentially, if there were just 3 of you here, 2 of you could approve or disapprove everything that goes on. So what we are trying to do is move forward on a motion. It is a motion of the board. We're not trying to relitigate the decision that y'all made. Because y'all don't have your own rules in place, and because the Administrative Procedures Act doesn't speak specifically to it, and we're always kind of like this, up and down as to where the Administrative Procedures Act applies in here, because the definition in the legislation or in the constitutional amendment was rules are defined by the APA, but it didn't reference it, and we haven't adopted it. Where that falls to Robert's Rules of Order. That's kind of the fallback. That's what y'all have historically followed. That's what everybody's used to following, but that's what y'all do. And a motion to rescind is allowed under Robert's Rules of Order. And all that is we're going to reconsider the order, or we're going to reconsider the motion and bring it back for and start all over. It's not turning them down. It's just moving us back to square one. The reason for this is partially because the process, and I'll get to that in a minute, and the other is what we believe is inadequate notice. I know that the MMC follows the rules, post it up on their website, and legally sufficient. What people don't take into account is, and we're always forward thinking, and what people don't take into account is the people that you're leaving. In this situation, it's unlike most. When you're trying to relocate an MMC facility, a dispensary especially, you're leaving a big hole in the availability of product to patients. And patients are the people who have been most important in this entire process. If you go back all the way to 2017 and 2018, one of the pillars of all of this has been patient access. And so a patient who has a dispensary in their neighborhood or within 5 or 6 miles of their place is not going to be going to the MMC website to make sure they're not being moved every month or that it's being considered. And the only time you hear about it, it's kind of like hearing about it when your grocery store moves out and Walmart comes in, or Walmart moves out. That happened in Brinkley a long time ago. They just tell you they're closing because they've already taken all those steps. And that's not a proper situation. Also, everybody doesn't get notice. It's easier to move a dispensary than a liquor store. A liquor store, you have to give notice. In a liquor store, you have to interested parties. You have to take in certain policy considerations, impact, and we don't really consider that, and the rules don't take this into consideration for medical marijuana. Although when we started this process, you had the zone maps were set up to ensure availability to everybody, that they didn't just go to the population centers. We also had the availability of when you were looking at making these decisions and picking. I know y'all weren't here, but some of the historical background is they wanted to make sure that everybody didn't end up clumped together. And in this case, you got lucky in the drawings because nobody ended up, or in the scoring, nobody ended up clumped together. And so we would like to have input and allow the patients to have input. Unfortunately, the way the rules are drafted, under medical marijuana, a party that might be hurt or damaged or harmed doesn't have the ability to appeal a decision. I can't file an appeal. The only person who can appeal the denial or approval of a transfer is the actual applicant. And that's it. So you don't have that ability to, if an applicant gets turned down, you turn them down, they can then come before the board and argue why they should be approved. But if a person is harmed, they can't. Now, if you apply the APA, again, back to this up and down situation, the APA allows, this is how broad it is, any person that might be harmed, that's a consumer, that's a competitor, that's a citizen, a governmental entity, they all have the right, they all have that secondary right to appeal. On top of that, they would have an opportunity on the front end. Since our only avenue is that narrow avenue of being in the first part of input, it's important that you give us the opportunity to speak. Give us the opportunity to give you a full picture. It's become about, well, we can't make enough money, and not about patient interest and patient access. You know, you're leaving a huge hole in two divisions or two areas, zones that are either going to be pushed to Missouri, taking away taxes, taking away access, but hours away from having access to their medication. And so that's all a problem that we have. And we just want y'all to take a moment, reconsider, set us back on one, and allow us to present you the total picture so that you're making the total picture instead of they've checked all the boxes, it was on the agenda, we can go forward, there's nobody here. And I know how hard it is to get able to speak and to do those things. It's difficult. It's difficult to find time to come down here. It's difficult to find time just to get on the agenda sometimes. And so you have to do that. And they've raised the issue to me about standing. This is not my motion, and this is not a hearing on the merits. This is a motion. This is actually a request to any of you on the board to make a motion to rescind the prior. This could be done. I could have walked up to any one of y'all and made this out in the public. You could have been sitting at a restaurant and heard two people talking about it, and it changed your mind, and you have the right to make this motion. It's a proper board motion, and you can do it on your own, and you can change your mind. It's not an APA situation because of the appeal situation, and so we want public input. That's what the APA is intends. It intends public input. Give everybody the opportunity. So we're just trying to go back and be able to give that opportunity to people who are interested and come forward. You're a representative body. Let everybody be heard. Don't just do one part of the industry. I understand the industry is the main part, but let everybody be heard. You may make the exact same decision, and that's okay, but at least everybody's been heard. We're in a weird situation also because, as the director just said, you filed rules. They included transfer rules. They've been hung up in
If I could interrupt for 1 minute, I don't believe we have ever introduced transfer of location rules to this
Okay.
body. It may have been discussed, and I think maybe it is something that was discussed, but
Something about posting the signage, which we were all in favor for.
we never
No.
drafted or turned
No,
anything in.
I'm
Just
not,
point of clarification.
that's fine. I'm not trying to speak, but what I'm saying is there aren't any rules for transfer currently. Some have been discussed or proposed, and our request would be to, if y'all are considering that, grant this motion, reschedule a meeting, either giving everybody a chance to talk, or the extreme version of that would be hold off on any transfers until you get some rules and regulations in place so that things could go forward. That's a secondary decision. The only decision you have to make here is that one of y'all decides you want to make a motion to reconsider. Motion to reconsider can be made by anybody on board. But because there's no written notice, and by that written notice y'all gotten from me, but one of y'all would have had to provide written notice that, hey, I'm going to make this motion, then it would be a simple majority. Because nobody made that, you have to have a 2/3 approval. That's what the Rule 37 of Robert's Rules of Order provides for. And that's where we are. We just want an opportunity. They asked for a continuance and it wasn't granted, and I respect that, but we're going to exhaust our administrative remedies first so that we can go forward. APA rules don't allow us to. This is all we have. So we would appreciate that opportunity.
Well, I do appreciate your comments. Commissioners, do you have any questions?
I do think it might be beneficial to hear from Mike.
Just to add, this store was previously located in Springdale and moved to Eureka, probably because we were a little crowded already. They also did that in anticipation of recreational passing, which didn't work out. But there's about almost the closest 3 counties will lose their access in a way that our state will forfeit those tax dollars to Missouri. And, for us on the west side of the zone where we're all stacked on each other already, we'll get another partner to just cannibalize what already exists there. Patient access, is something that's been a challenge in the state because naturally everyone wants to be in more populated areas. That is understandable. I just think that if an area had already been underserved and someone moved there to cover that area, it is really hurtful to the citizens in that area to move it back that way. But otherwise, I Mr. Langley said everything else I was going to say.
Have you all had citizens come to you and express concern?
We have.
Do you have emails, letters, anything like that?
We have. Yes, I don't have with me today, but Robert McClarty is.
And I think that's if you grant our motion, that becomes relevant at the time you take up whether the transfer is proper or not. We're just trying to get a motion to reset ourselves to zero. And so, but that's when that would be, yes, we have received it.
To be fair, shame on me for not going to the agenda website and checking ahead of time. But I found out about this being on, I got the agenda from ACIA 2.5 hours before the meeting. And that was when I saw that this was on the agenda. So we just did not have an opportunity to come to you guys.
And again, I will defer to the AG's office as far as legal arguments, but again, I will note that ABC has complied and will continue to comply with all legal notices. There are courtesy copies that get sent out by other associations. We can't control when those copies get sent out. And I would also caution it's a big slippery slope to start undoing every transfer of location you've ever approved.
And I know this is also in the minutes from that meeting.
And just to be clear too, for the
ABC
record, are we discussing the approval of permit number 113 in March?
Yes.
Osage Creek Dispensary?
Yeah, Osage Creek
Okay.
Dispensary, yes, ma'am.
Just for the record, so that everybody knows what we're talking about. But again, I would like the AG's position if you have one.
Yeah, so I do want to make 2 clarifying points. So Mr. Langley made a mention that the Administrative Procedure Act has a section regarding the ability for an injured party to bring an action. The APA does have a section on that, and that's specifically related to a judicial review, and that's when something has been adjudicated, and if someone wishes to appeal it to the circuit court. That is not where we're at today. There was not an adjudication of any sort. That transfer of location was an administrative matter, and this board does have rules regarding transfer of location, and those rules do not have a mechanism for reconsideration. Not only that, but your transfer of rules lay out specifically, and I know that it's been referred to as checking boxes. However, those rules do not include an objection by other parties. I understand the mention that alcohol has that. These are marijuana. These are the rules for y'all. So that's what rules do exist. They don't have that mechanism. Additionally, as I said, it was an administrative matter decided by y'all. The rules also, it was mentioned, but I want to make sure it's clear that the rules set out for denial. There are nothing for approval. It's denial if a licensee is denied transfer. That's 36, page 36, number 20 of the rule. So if someone was denied, they could absolutely appeal it to y'all, and then different rules would apply. Y'all have rules. There's not a mechanism for reconsideration. There would be no necessary to turn to Robert's rules. You have rules in place. They don't lay that out for reconsideration. The amendment is very clear on what restrictions apply for y'all. So the Administrative Procedure Act also is the governing of the state entity and of the boards, but they'll have the Amendment 98, they'll have the statutes, and they'll have y'all's rules. And they set out everything, and that was done at the last meeting. Additionally, that meeting was held in March, and here we are in May.
And there was a lot of discussion about notice, so to piggyback off of that, I don't think it's super fair to the permit holders who have no notice of this today.
May I just respond shortly? Or that's up to you. One, again, I admitted on the front end, there's not a process for this in the rules. There's not a process for when y'all meet, how you schedule to meet. There are no processes about how to conduct a meeting here in the rules and regulations. You still meet, you still do, you still have policies. This is a motion, it's not a reconsideration. Reconsideration has specific rules that it would have to have been reconsidered in the first time, or set out, if they adopt rules, a specific rule. I said, this is a default for a motion to rescind, which has a specific reference. That's 37. Motion to reconsider is Rule 36. What we're trying to do is simply take that up. I understand they didn't have notice. I sent a request in more than a month ago, 2 months ago, or a month ago, more than a month ago. They could have had notice, but nothing's sent out. And those are things, and that's the process. That's not the agency. That's just the process. And so, I sent that request. I don't think anybody got notice that the request had been granted or this was coming up. And so I respect that. But it's just as simple of, hey, can we reset? The decision hasn't been signed. It was 2 months ago. I showed up last month and was told to come back this month. And followed the rules and regulations and did what was exactly expected. And this is where we sit. This is not, as far as legal, I'm not arguing legal standing, and I'm asking for a procedural decision in regards to whether you're an aggravated party. There aren't any rules to be an aggravated party. Those folks are left out.
I do want to follow up. So I understand that the argument is that this is a motion to rescind, but ultimately what this board will be doing is reconsidering its decision already made. And I understand that the argument that's being made is that it's a process or it's how to run your meeting. However, the ultimate decision that's going to be made is affecting a transfer of location that has already occurred, and you have rules regarding that. This board cannot create rules without going through the rule process. So it is a different situation if we're discussing a truly procedural process at the meeting, I suppose, and I'm not saying that there wouldn't be rules hypothetically, but as it relates to what decision is going to be made, that absolutely, y'all have rules for it. So the rules are in place, and to create a new rule for reconsideration, which I would argue is what's going to happen, rescinding a decision, it has to be reconsidered. So we can call it different things, but that's what's being done. You don't have the mechanism.
Well, I'm of the opinion that, it's like, say, the Supreme Court, once they make a decision, that's it. There's no change. But once we make a decision on transferring a location or transferring ownership, we can't go back and say, just kidding. It's, do you guys have any comments?
Thank you for your opportunity.
Thank you.
Thank you.
Do we have anybody else that was?
I think this is the only person that we expected, but if you are opening up to open forum, we can do it.
Chip, do we have anybody else?
All for everybody else.
Okay. Commissioners, any other questions, comments?
And I would just clarify too, ultimately, the commission through Mr. Miller has the authority to say what hits on the agenda. If you guys would like us to discuss internally how we do that, I know maybe there was some discussion about like an open floor today, if we want to specifically put like certain items, but I again would caution on request for reconsideration, just kind of becomes a slippery slope and may at that point become practice.
Right.
So we can discuss that further. Also, if, obviously it's not a secret that like we have heard about transfer of location rules and how they are different from what I do on the other half of my job, which is alcohol. So if you guys want us to draft some things up, we can try to get those in at the same time as the management rules and the
I would
licensing
like
rules.
that, actually, and I think we had discussed it informally, not officially, but, I do agree with posting signage, maybe X amount of days before, just to give, a notice to the public that maybe don't
And then
check it with, we necessarily do.
Sure, and another thing too, just for brainstorming or to create a forum for community involvement, we could just add it as an agenda item and kind of have an open floor discussion where people can say, I like the way alcohol does it, let's put up a sign, and then other people can say, I think we need to put it in the newspaper or online or whatever. That way you guys kind of get a feel for what everybody's thinking, and then we can draft based on discussions from there, just so that it's not us getting it out of nowhere.
I like that, yeah.
So it may not run on the same table as the other two if we approach it by that method, because then we're kind of brainstorming on the front end. But I don't know if there's any industry members here who would like to speak on if they would love to be involved in that or not.
Sure.
Seeing some head
Absolutely.
nods. So maybe that's a way that we can kind of all compromise in the future going forward.
Agreed.
I got one question on this issue that was just brought up. Was there anybody here that day to speak in favor or against?
I believe there
Remarks, I'm sorry, I was listening to that.
there was a request for a continuance with the argument made that we didn't get notice. And I very vehemently was like, we complied with all notice requirements.
Okay, I think I remember that.
Yeah, if I remember this one correctly, it was, started in like November and they kept pulling it off agenda and then kept putting it on every month.
That's what I was gonna say, it was like a revisit, so that, yes, yeah.
Yeah.
But I didn't have my notes in front of me.
And I just heard Chip whisper, but I do think we received a letter
Yeah, Senator Hester.
from Senator Hester on that one, yes, which we would have passed out to all as we said.
Right. Yes.
Outside of that, I have no other business, but if you guys would like me to put a agenda item for an open floor discussion about transfer of locations, I can do that. If you want to wait and schedule it later, I can do that as well.
You want to do that at the June meeting? Because we should have a light agenda in June.
Fingers crossed.
Would we pause transfer location until we decide?
We pretty much pause transfer locations until we get through with our rule process, so.
Okay.
Yes, yeah, let's put it on the agenda for June
Okay, and
as just a discussion.
just, I heard a little bit of discussion here just then about pausing. I want to be very clear for the record and for everyone else in here. Are you requesting a pause of transfer of ownership or transfer of locations until that discussion is had? Or once that discussion is had, you would request a pause? Just so
Well,
everybody knows.
I mean, I think that we need to have the discussion, we have the discussion in June before we entertain any requests
Agreed.
for transfer of locations. Let's
Yeah.
get through June and go through all those, and then we can figure out from there. So basically for 1 month.
And Chip just whispered to me that there currently are no requests for transfer of locations on the June agenda. So
Okay.
we'll just add an open forum discussion. We'll put that on the agenda, and you can decide at that point in time if you want to limit people to 3 minutes or 5 minutes or
We'll see how many people we get.
however you want to do it.
Thank you.
So,
That's all I've got.
It's good. Thank you.
seeing nothing else, Commissioner, if you have any questions, comments? Okay, we're adjourned.
This conference is no longer being recorded.